So with that, let's go ahead and get started. I'll go ahead and turn the webinar over to our longtime member and AAPS board member, Dr. Robert Emmons, who will make a few brief introductory remarks and also introduce our main speaker. Dr. Emmons, please go ahead.
Thank you, Jeremy, and thank you again for all the work you've done in putting this together. Welcome to everyone. Welcome to old friends and new friends. This is the second in our AAPS webinar series that we've just kicked off, and the purpose of this webinar series is to promote collegiality. At a time like this, with the pressures that American medicine is under, we really need each other as colleagues, and we need to be talking to each other directly without third parties getting in between us. We aim to provide important information that's relevant to clinical practice now. This is clinical information that's curated by clinicians for clinicians. I'm really excited and looking forward to Dr. Lilly's presentation on the prescription drug monitoring programs. That's certainly a topic that I've followed with alarm for years now. AAPS has kept me up to date on the topic, and this is actually a topic that has a lot of relevance, even though it might have started with opiate prescribing. It has a lot of relevance to the current controversy around treating coronavirus, and it's relevant to the controversy around hydroxychloroquine prescribing and the freedom of physicians to prescribe. We're going to have these webinars every 2 weeks. In 2 weeks, Dr. Phil Eskew, who's on the line tonight, he's participating in the webinar. He'll be our speaker, and he's going to speak about direct primary care. And that's always a great topic. But once again, direct primary care is very relevant at this point in time when governments are shutting down some forms of medical practice. I think we can all agree that direct primary care is a very resilient model. And Dr. Eskew is going to be talking about that and giving us updates about the legal framework. So I have a couple of logistical things to say as well after introducing these speakers tonight and our next one. We are going to have a very active chat room. And if you have not been to an AAPS meeting before, you will notice that people who participate in AAPS really like to speak up. We believe in freedom of expression. So there's going to be all kinds of things going on in the chat room. This does not represent official positions of our organization, but we want physicians to be free to speak out whether we agree with them or not. And we want to promote collegiality, which means when somebody disagrees with you, you're still respectful of them. I'm also going to be a timekeeper, and I'm going to jump in. I'm going to turn my face off in a moment here when Dr. Lilly starts, but I'll come back on at about 45 minutes to call an end to his formal presentation. We'll have 45 minutes for question and answer, which Jeremy will very ably run the question and answer session. We'll finish up around 10 p.m. There may be some questions that don't get answered. We may run out of time, and Dr. Lilly very generously has agreed to be available to take questions by email and other forms of correspondence after the presentation. So we apologize if you don't have a chance to get your question asked tonight, but we will follow up with you. And finally, we're investigating forming ongoing small discussion groups. Many participants last time expressed an interest in that, and we're working on the logistics for that, and we'll be back in touch with you. So that's the logistics. Let me introduce Dr. Lilly. Dr. John Lilly received his bachelor's degree in 1977 with a biology major and his Master of Business Administration degree in 1979 from Washington University in St. Louis. He got his Doctor of Osteopathic Medicine degree from Kansas City University of Medicine and Bioscience in 1997. He completed his residency training at the Cox Family Medicine Residency Program in Springfield, Missouri in 2000, and he's currently practicing family medicine with the Mercy Clinic in Springfield, Missouri. Dr. Lilly has been studying the prescription drug monitoring program for 6 years and he's testified against that program at hearings in the Missouri House and Senate for the past years. We thank you very much for that advocacy, and we look forward to your talk. Dr. Lilly.
Thank you very much. Let me pull it up. Let me share the screen. Okay. Now, how do I get this thing out? Okay. There we go. Can everyone hear me?
Yes, Dr. Lilly.
Okay, good. Oops. Excuse me. Technical difficulty here. Sorry about that. Okay. Now I lost you guys. There I go. Share screen. And okay, now I can see everything. This is about intentional solutions with unintended consequences. Disclosures are none. Disclaimers. I always have to put this thing up. Any opinions expressed in this presentation are solely mine and do not necessarily reflect the position of organizations or businesses with which I am affiliated. And I'm having trouble getting there it is. Let me get this out of the way. All right, objectives. CDC guideline for prescribing opioids for chronic pain. There's two things: flaws and inappropriate aspects of the guidelines and how they are affecting patients' lives. Okay. Prescription drug monitoring program. Objectives is talk about the government ignorance, the failure of the programs, how it infringes on individual liberty, and the real purpose. You're probably familiar with this. This is the CDC guidelines. This is in the guidelines that talks about the types of evidence. Type 1 evidence, randomized clinical trials, or overwhelming evidence from observational studies. Goes down to 2, 3, and 4, getting less and less strict, down to 4, clinical experience or observations, observational studies with important limitations, randomized clinical trials with several major limitations. The government imposes the type 1 evidence on us. When pharmaceutical companies go into the FDA for approval, they have to do randomized clinical trials. Now, what does the CDC guidelines, this is what they say in their guidelines. Type 1, how many of the 12 recommendations that they have are type 1? None of them are. How many of them are type 2? There is 1. How many of them are type 3? 4. And there's 7 of them that are type 4 evidence, which is not very good. If that was somebody in the private sector going to the government, they would say, start all over, come back when you've got better evidence. But did they do that? No, they went ahead and published the data. The first one, this tries to, they say, try to use the least risky therapy first and increase the therapy only as needed. Their second recommendation is, before you start opioid therapy, talk with the patient about risks and benefits and set some realistic goals about pain. That's another reasonable goal. Number 5, this is one of the key recommendations. It sets limits on opioid prescribing to 50 morphine milliequivalents per day and a maximum of 90 morphine milliequivalents per day. There's one big problem with this. They completely ignore individual metabolism. And this is one of the unintended consequences of the CDC guidelines. Number 6, it talks about how you should prescribe them, and at the bottom it says, more than 7 days will rarely be needed. Well, the Missouri State Legislature, in all of its infinite wisdom, a few years ago passed that type of law. It said if you prescribe an opioid for the first time, you can only do it for 7 days. And that has unintended consequences. Last year, I had a patient that broke his proximal humerus and went to the emergency room, where they put it in a sling and set up a appointment with an orthopedic group in 10 days and gave him 6 Percocet. Well, he called up the orthopedic group and said, I need some more pain pills. I said, we haven't seen you yet, so we're not going to give you any. So what does he do? He calls his primary care doctor, me, says, I got to have some more pain pills. So I can only prescribe him 7 days of pills. 7 days of pills pass, and he calls me back saying, I got to have some more pain pills. So the unintended consequences of their well-intended laws were to make more work for me, uncompensated work, and just make more problems within the medical system. And the 11th one was the one about prescribing opioid pain medicine and benzodiazepines concurrently. This has been a problem because millions of people have taken pain medicine and benzodiazepines for years, and now they're being forced to choose between their pain medicine and their anxiety medicine or their sleeping medicine. This is a paper by Dr. Richard A. Lawhern, who's a PhD, who is the founder of the Alliance for the Treatment of Intractable Pain. And one of the topics that it covers is the confounding problem of individual metabolism. There are 6 key liver enzymes that are involved in 90% of all medications. The expression of these enzymes can vary by individual. Poor metabolizers pass low amounts across the blood-brain barrier, so you don't get much pain relief, and hyperactive metabolizers metabolize fast, you don't get any pain relief. Some pain management specialists identify the range of minimum therapeutic dose for opioids as 2 to 1,000 morphine milligram equivalents. And there are published case reports of hyperdose patients who do well on dose levels over 2,000 with no unacceptable side effects or observed symptoms. This is an actual lab, Quest Lab report from one of my patients. I'm going to zoom in on the main part. The patient does not carry the COMT Val 58 MET variant. The patient may require higher doses of morphine for adequate pain control. CDC guidelines completely ignores this. And there have been a lot of patients that have taken high doses of opioids and very safely for years are now being forced to reduce the amount of opioids that they have been taking. In the guidelines, it says, the recommendations in the guidelines are voluntary rather than prescriptive standards. And that's kind of their catch-all phrase to say, you know, we're not responsible for anything. These are just suggestions. Well, they're not suggestions if insurance companies and pharmacies now take these as their standards that they do not deviate from, such as Walmart has. So this is, this came out from CMS in 2019, and this has a number of, this was an announcement in 2018. It's got a number of policies for 2019 from CMS, from Medicare. It says, let me get it. Given the urgency and scope of continuing national prescription opioid epidemic, CMS is finalizing a number of new policies for 2019 to further help Medicare plan sponsors prevent and combat prescription opioid overuse. Now, they talk about prescription opioid overuse. Okay. This is the prescriptions that have been written per capita across the US. They peaked in 2012, and the high dose opioids peaked in 2008. So they've been going down. We really don't have a prescription opioid crisis. Opioid naive patients, to reduce the potential for chronic opioid use or misuse, we expect all Part D sponsors to implement a hard safety edit or limit initial opioid prescriptions for the treatment of acute pain to no more than 7 days. I've already talked about how this is a problem. Chronic opioid users, we expect all sponsors to implement real-time safety alerts at the time of dispensing as a proactive step to engage both patients and prescribers about overdose risk and prevention. CMS recognizes that a tailored approach is needed to better address chronic opioid overuse at the point of service. We expect all sponsors to implement an opioid care coordination edit at 90 morphine milligram equivalents per day. This formulary level safety edit should trigger when a beneficiary's cumulative MME per day across their opioid prescriptions reaches or exceeds 90. Sponsors will also have the flexibility to implement hard safety edits, which can only be overridden by sponsors, and set the threshold at 200 MME or more, and may include prescriber or pharmacy counts. Opioid users also taking duplicate or key potentiator drugs. Lastly, we expect sponsors to implement additional soft safety edits to alert the pharmacist about duplicative opioid therapy and concurrent use of opioids and benzodiazepines. So Medicare sponsors are getting the direction to put these CDC guidelines actually in place and to hold prescribers to it. So the doctors are losing our control over what our patients are taking. So what does this lead to? There was a Fox News had a special last year. This was it. As doctors taper or end opioid prescriptions, many patients are driven to despair and suicide. So because of the government edicts and its unintended consequences, our patients are being harmed, and some of our patients are even committing suicide. So I'm going to switch gears now, talk about the prescription drug monitoring programs. This is the category of the opioids, the ICD-10 codes. Those three are prescription ones now, except for fentanyl. Since 2014, fentanyl has been a prescription opioid and a illegal drug that is manufactured mainly in China and Mexico and is coming in pill form. So the CDC doesn't know what to do with the T40.4 category. I even asked them, I sent them an email. I said, does the CDC 10 code T40.4, synthetic opioids other than methadone, include prescription medication as well as similar illegal drugs? Their reply was, the ICD-10 code T40.4 classifies deaths due to poisoning by a similar class of opioid compounds other than the compounds T40.2 and T40.3, with no distinction on whether a compound or formula was obtained or manufactured illegally or legally. They look at what is on the death certificate, and when it says fentanyl, they could not figure out whether that was prescription fentanyl or whether it was illegal fentanyl. Well, I figured out a way to at least estimate the illicit and legal fentanyl. This was a paper I wrote that was published in our journal back in the spring of 2018. They published my most recent one about the failure of the prescription drug monitoring programs last summer. This is where you go to get the information. CDC Wonder website, down you click on the multiple causes of death. This is what the National Institute on Drug Abuse and everybody else uses for their data. This is one of the charts that you can get from it, and it's mainly you look at the age-adjusted rate per thousand so you can compare different states. This is the deaths by per capita for all prescription pain relievers in the US since 2000. There were 16 PDMPs operational in 2000. That went up to 21 in 2005, 34 in 2010, and 49 in 2014. When I testify to the Missouri State Legislature, I show them this and say, when are the death rates going to start coming down? And nobody can give me an answer. And they usually say, well, at least they're not getting worse. Well, that's something you can't prove. That's a logical fallacy. Now, this is state by state from 2000 to 2000, the death rate. This is 2000, 2001, 2002, 2003, 2004, 2005, 2006, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, and 18. So that looks pretty bad, but this is the deaths per capita due to all illicit fentanyl. This is the maximum. The worst state in 2018 was West Virginia, and that was their level. 2014, this was a number. 2015, 2016, 2017, and 2018. There are now 13 states that have a higher death rate due to illicit fentanyl than prescription opioids. This is another graph of the number of deaths. The blue is prescription opioids only, the red is illicit fentanyl only, and the green is where illicit fentanyl and prescription opioids were both on the death certificate. This shows you the number of the various categories. And as you can see, the illicit fentanyl continues to go up. Prescription opioids were fairly stable and then started to go down recently, not because of the prescription drug monitoring program, because there's something easier to get, which is illicit fentanyl. So one of the things that they always talk about is you got to stop doctor shopping. Everybody was getting all these prescription opioids through doctor shopping. Well, I found this, the National Survey on Drug Use and Health. This survey was started in 1971, very big sample sizes, as you can see. 9.9 million people over the age of 21 misused prescription pain medicine in 2018. That was 3.6% of the US population. So how many of the misusers of prescription opioid pain medicine got it from doctor shopping? Well, if you go through the survey, this is a huge survey, it was 2.8% got it from doctor shopping. 83% got it from one doctor, either personally or from a friend or relative, and 14.2% got it from someplace other than a doctor. So the real problem is the 97.2% that got pain medicine that was misused from something other than doctor shopping. That is why prescription drug monitoring programs don't work. They will never catch 97.2% of the misused pain medicine. And now it gets even worse. 2011, they started asking this question about where do you get it? And in 2011, it was 3.6% got it through doctor shopping. It went up in 2012, 2013, and 2014. And then it took a sharp drop in 2015, went down a little in 16, and then went up again in 17 and 18. Why did it take the sharp drop? It took the sharp drop because they changed the question in 2015. From 2011 to 2014, they asked, over a lifetime, have you misused prescription pain medicine? From 2015, it was the last 12 months. That's why it took a sharp drop. So even with all of the PDMPs across the country, in 5 of the last 6 years that you can compare the doctor shopping actually went up. So they can't even stop the tiny amount of doctor shopping that's out there. So where did this come from? This came from a government commission. There was a President's Commission on Model State Drug Laws that was formed in 1993. There was a bunch of congressmen that went on a fact-finding mission. And this organization was initially set up to control illegal drugs and alcohol abuse. As they went along, they took up prescription drug monitoring programs as a cause. This is a map of the established and operational PDMPs, and notice they now call it PMP, Prescription Monitoring Program. It is all over except for Missouri. Missouri is the one state that does not yet have a statewide PDMP. They have one that was written, that's out of St. Louis County, that now 84% of the population of Missouri is now under. These are the states that legally authorize the sharing of prescription drug monitoring program data with other jurisdictions. So we're almost to National Prescription Database. National Drug Control Strategy. This came out just 2 months ago. Part of this said, we will continue to work with our key stakeholders to build on existing research regarding barriers to nationwide PDMP implementation and drive PDMP integration and data sharing, including efforts that address any legal and interoperability challenges. We'll also pursue incentives for states to make checking PDMPs mandatory for all providers. So yes, they are trying to make this mandatory for everyone. This is a white paper that was done last year about the standards-based facilitator model for PDMPs. And if you had any question on what their ultimate goal was, this was one of them: create a comprehensive repository for all PDMP data. That is their ultimate goal. This is one of the charts that they had about how the PDMP works, and one of the keys is this thing, the private care facilitator. Aprius Health provides a common platform and software solutions for 42 of the 52 established prescription drug monitoring programs in the US and the US territories. So there's one company has 42 of the 52 PDMPs. They are the private sector facilitator. So what's the real reason they're doing this? The real goal is to get a national prescription database. Now, they're not that far from it. This is the part of Nebraska's statutes. You zoom in, and part of their statute says such system of prescription drug monitoring shall be implemented as follows, except as provided in subsection 4 of this section. All prescription drug information shall be reported to the prescription drug monitoring system. Prescription drug monitoring system shall include, but not limited to, provisions that prohibit any patient from opting out of the prescription drug monitoring program, require any prescription drug that is dispensed in this state to an address in this state, or entered into a system by a dispenser or his designee after such prescription is dispensed, including prescription drugs for patients paying cash or otherwise not relying on third-party payer for payments. This is current legislation that is trying to go through Maine. What they did was they took their controlled substances prescription monitoring program and just scratched out controlled substances on all of the statutes and added no later than January 1st, 2020, the department shall expand the programs to include the reporting of and dispensing of all prescription drugs. I looked at their website, the main website, and they had a hearing, and there was 105 people that made comments to that. Almost all of them were saying, no, don't do this. One of them was our own Dr. Orient on behalf of direct primary care practices in the state. So why is this unconstitutional? This is a Missouri Constitution. A lot of people will go to the federal Constitution and talk about Amendment 4. First, start at the state level. All of the states have in their, generally, Article 1 is their Bill of Rights. This is Missouri's. The people shall be secure in their persons, papers, homes, effects, and electronic communications and data from unreasonable searches and seizures, and no warrant to search any place or seize any person or thing or access electronic data or communication shall issue without describing the place to be searched or the person or thing to be seized, or the data or communication to be accessed as nearly as may be, nor without probable cause supported by written oath or affirmation. So what's the problem with databases? Private insurance companies, government programs, Medicare, Medicaid, and the Veterans Administration all have prescription databases. When you sign up for the insurance policy of the government or program, you agree to become part of that database. PDP is completely different. It is a mandatory, involuntary database, which makes it unconstitutional. In fact, only 11 states will even tell you that your data is going into a database. So what's this for? This is so the government can control physicians and ultimately citizens. Let me wrap up a little bit with the coronavirus. This is the AAPS website. I'm sure you're familiar with that. Down at the bottom of that is this paper that was an excellent paper. A little lesson from history. This was the Spanish flu back in 1918. You can see in Philadelphia, they had a terrible spike in the deaths. And a lot of people will say, well, they delayed in doing social distancing. The first case in St. Louis, they started the social distancing right after that. But what they don't include is one of my friends, Darren Chappell, who is an expert historian and constitutionalist, noted that in 1918, the mayor of Philadelphia refused to cancel the Liberty Loan Parade on September 28th. The parade stretched for 2 miles through downtown Philadelphia. Just 72 hours after the parade, all 31 of Philadelphia's hospitals were full and 2,600 people were dead by the end of the week. The mayor of St. Louis canceled the parade. So that parade came just a week before they started the social distancing, and you can see right after that, it started to skyrocket. So there is some question as to why did Philadelphia do so bad? There is an argument to be made for they didn't cancel this Liberty Loan Parade, St. Louis did, and that was the difference, not the social distancing. Point to this is there is enough variation among the states and local municipalities across the country that future research from the coronavirus outbreak should provide ample evidence about social distancing, stay-at-home orders, and other directives issued by political subdivisions to determine what effect it had on the morbidity and mortality. So if you had the questions, if you did the pre-test questions, number 1, the answer was 200. Number 2, the answer was false. Number 3, the answer was false. Number 4, the so-called answer was true, but in reality it's false. Number 5, the answer was 0 to 19. It's actually 2.8. And number 6, the answer was 48. So these are all my references. So now, let me go back, stop sharing, and let everybody else come in on this.
Okay, Dr. Lilly, thank you very much for that excellent presentation. I really appreciate that. And so we'll now go ahead and start with Q&A. Again, you can submit a written question in the Q&A box down at the bottom. Also, if you raise your hand, we can come to you for a verbal question. So please go ahead if you'd like to click the raise hand button. We'll come ask you a question. So there are a couple already in the Q&A box, written questions. One is just a comment. I have 3 issues with the DEA. They don't respect the Fifth Amendment. They are charging $731 for a background check for a renewal. And also, I've heard this from other people too. They refuse to allow a doctor to use their PO box for their DEA number. Not every physician has an office per se. So, any comments on that, Dr. Lilly?
Oh, I agree. Yeah, he's got a very good point. This is something I have not had. I'm not an independent physician. I am in a large group, but those are all very good questions and comments.
Okay, yeah, we have some other. Thank you. We have some other written questions here, and I just saw a hand raised too. So we'll come to that, the raised hand in a minute. But a question in the Q&A box. Dr. Lilly, would you comment on SHINE? That's an acronym, SHINE, the medical data bank for the state of Missouri, and how you feel this may be involved in the PMP plans.
I am just vaguely familiar with that. So Dr. Powell could, I can't answer that question because I'm just vaguely familiar with the SHINE. But I think the PDMP in Missouri, it is now, it passed the House and went to the Senate. They had a alternative and it went back to the House. So I don't think it's going to pass this year, but we'll see.
Okay, thank you. Thank you for that question and answer. All right, we'll go to one of our attendees here who's raised her hand, and this is Dr. Weris. Dr. Weris, you should be able to speak now. Please go ahead.
Oh, hi, this is Dr. Nancy Veras from California. Can you hear me?
Yes, thank you for joining us.
Okay, well, I sent in that first question, but it was a question because what I want to know is what to do. Should I go to the Department of Justice Office of Inspector General and complain? Because I've already gone to the supervisory level about both the price tag on the $75 background check that they're charging $731, plus the post office bar. I went to the supervisor, so and I sent it on to the head of the DEA. So should I go to the Office of Inspector General, DOJ, Michael Horowitz, of course he's very busy, or DOJ Civil Rights, or should I go right to the White House, or all of the above? But if I do any of these things, I'd rather go with a group. I cannot believe there's not a single other doctor, even if you have the dough to spend this $731. It's the principle of the thing. I have had background checks up the kazoo. And all this money, it's going to pay the salary, benefits, and pensions of these DEA diversion program employees. It's not going to anything, and it's really unfair. The whole issue of the post office box, it's because they assume that I am a criminal receiving opioids in my box. See, this is the principle of the thing. And so that's why I don't understand why there's not a single other physician, especially you physicians who still have money, and that you don't want to help the civil rights of other and defend the Constitution on these issues. And all these issues seem to be constitutional, where our government bureaucrats and politicians like Mike Pence do not respect the Constitution.
I would have to
What
refer
say you?
to our attorney, Mr. Schlafly, to answer some of those. Andrew Schlafly.
Yeah, and Mr. Schlafly is on with us tonight, I believe. Mr. Schlafly, if you'd like to weigh on any of these, please raise your hand, and we'll come to you here. So there are some other questions like that. We do have other questions in the Q&A box, and
yes,
one of them is, has the legality of any PDMP been challenged in court? And I know a little bit about that, but I'll let Dr. Lilly take a swing at that if he wants to first.
As far as I know, there hasn't been, but I'm mainly familiar with Missouri.
Right. Right. Okay. So this, I came across this a few weeks ago when you brought up the state of Maine, when we were looking into what the state of Maine was trying to do to have a PDMP for every prescription, not just controlled substances. We were looking at this a little bit, and so it turns out that in 1977, New York State implemented a PDMP way back then, and it was challenged in the Supreme Court, and there was a case, Roe versus Whelan, 1977, where the Supreme Court ruled that New York did have the power to create a PDMP as part of its quote-unquote police powers. But there's, we were looking at Maine, that if it did pass in Maine, that might be another chance to get the court to revisit that ruling.
Yeah, there was another question that said, what makes PDMP an unreasonable search and seizure? Because it is going to a database that I did not agree to. So again, if you sign up for insurance, that all goes to a database. When you agree to the insurance or a government program, you agree to that database. And one of the last time I testified this year in the Missouri Senate, one of the senators said, well, there's databases here and there's databases all over the place. Big deal. What's another database? Well, yeah, it is a big deal.
All right, good point. Thank you. And let's see, Mr. Schlafly did raise his hand, and Mr. Schlafly, I have you, I think, ready to speak here if you'd like to say something. Thank you for being with us tonight.
Yeah, I'm on here, and I'll put on my headset so it's a little better microphone. So
okay, we can hear you pretty well.
Okay, well, this might be even better, but this is an area of the law that unfortunately is not developed as much as it should. Here on my microphone. Wait.
Okay.
Yeah, here we go.
Oh yeah, that's better.
Yeah,
I
this
think.
should be better. So instinctively, we should all have constitutional rights to the data that companies compile about us, like our phone records and our bank records and our prescription records and all medical records, all that stuff. You would think that the Fourth Amendment would protect the individual about whom those records refers, but it doesn't. The constitutional law is not developed in that direction, and unfortunately, the Supreme Court has allowed subpoenas without concern for the Fourth Amendment to go after data that other people are holding about individuals. So there's really no Fourth Amendment protection when government goes after someone's medical records that are in the possession of somebody else, or bank records that are in the possession of a bank, or prescription records that are in the possession of a pharmacy. Now, there is a case before the U.S. Supreme Court right now, the Zeta case, where we filed an amicus brief. And in that case, the Texas Medical Board did a search of a doctor's office without a search warrant and grabbed a whole bunch of medical records without a search warrant. And the doctor has asserted his Fourth Amendment rights, both on behalf of himself and the patients. And the Fifth Circuit, U.S. Court of Appeals for the Fifth Circuit, recognized that the doctor does have Fourth Amendment rights and that there should be a search warrant before those records are seized. However, the U.S. Court of Appeals for the Fifth Circuit found that the Texas Medical Board had qualified immunity, so they would not be personally liable for infringing on those Fourth Amendment rights in this case. That's been gone on petition to the U.S. Supreme Court. We filed an amicus brief in that case to say not only are there Fourth Amendment rights here, but when government officials violate those Fourth Amendment rights, then they should be personally liable too. There should not be immunity or qualified immunity to protect the government officials when they infringe on these Fourth Amendment rights. So the law needs to develop more, and AAPS is at the forefront in doing this and trying to establish Fourth Amendment rights by people in these records. But we've got a ways to go. And it's unfortunate they're building all these databases with prescriptions and other things in them. And right now, it's not clear that patients have Fourth Amendment rights in those, but they should. And so we're going to continue to work on that.
I see one of the questions is about, years ago, the government was telling us to write prescriptions. And this was Edward Coleman. He's absolutely right. Back in late 80s and early 90s, they came up with pain as a fifth vital sign and said, you guys, doctors aren't writing enough prescriptions to control pain. In fact, when I was in medical school in the mid 90s, the Missouri Board of Narcotics and Dangerous Drugs came to our school and said, you guys need to prescribe more opioids. So, now 25 years later, they turn around and say, oh, you guys are prescribing too much. So yes, they did. The government is quite hypocritical and doing the exact opposite of what they told us to do years ago. And another one is asking that many pharmacies, and I find this true also, is requiring physicians to enter the diagnosis on an opioid or they won't fill it. And he says he's refused because it's a violation of patient privacy. So yeah, that is another thing that pharmacies are doing now. I've even had one of my colleagues, they completely changed one of his prescriptions without telling him about it because that was the quote pharmacy's policy. So it is getting to where the pharmacists are becoming very active in this and are essentially playing doctor.
Thank you, Dr. Lilly. Okay, I see there's another hand raised, but there's also a question in the chat room. Can you explain more what will be done in the future to stop states from creating general medication databases? How could the states use these medication databases to further control physician prescribing? Well, I think that's that's part of the intention. They want to keep an eye on the prescribing, so they can step in if they don't like something about that. That's a very good point. Yeah, I think that they're actually stating that. Dr. Lilly.
One of the things that we changed our Missouri Constitution on firearms a few years ago to include a little phrase that said, unless there is a judge that tells, has an opinion that someone is mentally incompetent or has some mental disease. And what they did was open it up to, if somebody says, well, if you have PST, the post-traumatic stress disorder, you have a mental illness and you can't own a firearm. That's what and then they'll use the database to go through and find everybody that is on medication for that or has that diagnosis. And then they'll go say, okay, you can't have any firearms, and these red flag laws that are coming into vogue over the past few years are written so that the police, even without a warrant, can come to your house and remove all your firearms.
Okay, yeah, thank you, Dr. Lilly. Okay, let's see, we're gonna go to Dr. Kessner. I hope I'm pronouncing that right. Please correct me if I'm not. Dr. Kessner, please click the unmute button on your screen there that you should see.
Okay. I was keen on Dr. Schlafly's commentary on the qualified immunity that they will trot out relative to collecting information. I've listened to a, what do you call it? I'm sorry, Ninth Circuit Court in California on appeal where a person with Child Protective Services had falsified data in order to remove a child from their home. She was being represented on appeal at taxpayer expense, and the lawyer was claiming qualified immunity and absolute immunity for this transgression, which some of the justices actually moved forward over the bench to say, what are you talking about? Now, the case hinged on the fact that she had lied to the courts. So why do we, as free people, hold government employees to be perfect and not to have any repercussions for their bad performance? There's another excellent book written on that concerns the Department of Justice that I wish I could remember the author right now, but it's Licensed to Lie is the title on it. I recommend it because I know you guys got a lot of time free to read. But I applaud AAPS for taking a constitutional stance against the encroachment of government because it adds cost. We all know that, okay? And it's easy for them to impugn the motives of people, both doctors and patients, by just looking at data. They do that to build an empire, and we need to stop it. How can we do that? In large part by juries. You need to know that the people's rights are still protected within a jury situation. If you can get on a grand jury, that's even better. Thank you for allowing me to comment on that.
Thank you. And it looks like someone put the book title there in the chat room. Any comments on that, Dr. Lilly?
No, that was good.
Okay, thank you. Let's see. We have we're going to go to Dr. Ritz here. Dr. Ritz, please go ahead.
Thank you. Can you hear me okay?
Yes, sir.
A couple of comments. Thank you for the great presentation again. First of all, the APS pointed out to me many years ago when my software couldn't get compliant for HIPAA. Once you sign up for HIPAA, then you waive the warrantless search. And if you stay as a country doctor in the clause in the HIPAA law, then you stay under the original doctrine of warrant of the Fourth Amendment and your state constitution. So want to remind everybody about that country doctor clause that you cannot allow. And I've stood down many county officers from the health department wanting to see my records. And I tell them that, no, you have to have a warrant. And some of them carry guns. And I just say, fine, I'll call the local enforcement if you don't believe me. So just a comment about that. The second thing about the situation, when I was in the state legislature in Oklahoma, I fought the PMP laws for 10 years. And another physician who was basically in cahoots with the agencies, they said, oh no, we have to have it. And I said, I didn't see the value of it. And I even went a step further and I said, why do we even need a DEA license, a federal DEA license, when the state narcotics people tell me that they do all the investigations and the DEA very rarely involves them. So I authored a bill in Oklahoma. It didn't get very far. And my main opposition was actually from the pharmacy boards and the medical association because I felt like it was a duplicity of services when the state could service that. The third thing I just wanted to comment on is I'm a senior FAA examiner for pilots, and I'm getting feedbacks from my pilots, both from the Guard and from the commercial airlines, that the FAA is telling them, they're threatening them if they dare go on hydroxychloroquine for the COVID, they will yank their licenses.
Thank you for that information, Dr. Ritz. That's very disturbing, and thank you for your efforts in the legislature to push back on and stop some of these bad ideas. I don't. Dr. Lilly and Andy, did you have any follow-up comments to that?
I just wanted to say the Missouri State Medical Association is one of the biggest pushers of the PDMP in Missouri. So yeah, it's a lot of the established organizations are the ones that are behind it.
Yeah, and I'd like to jump in, Jeremy.
Please.
The point that Dr. Ritzy just made about not consenting to searches, even though the officer shows up, has a gun, and is very intimidating. That's so important, not to consent. If they don't have a search warrant, then the only other basis they can really use for searching your medical records or searching your home is if you consent to it. And they're trained to get that consent in clever ways. And you've got to realize that. And you've got to state that you do not consent. You object, you ask them to leave. Now, if they come in and search anyway, then they're legally accountable for doing that. But they will try to get your consent or the consent of your office manager or family member or whatever. So you have to train them as well not to consent, to object and say, object to this, I'm going to ask you to leave. You know, really, you're trespassing. This is private property. I'm going to ask you to leave. Please leave. You know, please leave now. And even if they have a gun, I mean, you still can say that to someone who has a gun, an officer who has a gun. The other thing I want to circle back to the point about immunity. We made some of those points in the brief we filed with the Supreme Court, and the Supreme Court is considering that issue right now, this issue of qualified immunity. And if you think it through, as we argue in our brief, it really does not make much sense for government officials to have qualified immunity when they egregiously violate constitutional rights. There's really no rationale that justifies that qualified immunity. One of the things they said on the other side in this case is, well, the Texas Medical Board, they've been doing this for a long time, going in and searching medical records and private physicians' offices without a warrant. Well, just because they've been doing a long time, that doesn't mean that they should get immunity for doing it. Just the opposite, I said, just the opposite. They've been doing it a long time, all the more reason somebody needs to be penalized in a meaningful way with actual damages so they stop doing it. And in fact, in Texas, there were a number of these lawsuits pointing out that this was unconstitutional, and the Texas Medical Board continued to do it because nobody was being held legally accountable for it. And once someone gets slapped with a $5 million judgment, and that's all over the newspapers, and the legislature has to figure out some way to budget that, or the person has to pay it out of his pocket, then the constitutional violation will actually stop.
Thank you, Andy. And there's a follow-up question for you on that. But before I go to that, I forgot to mention, if you're on the phone and want to raise your hand, if you're dialed in, *9 will raise your hand. So my mistake there, please. So if you're on the phone, there's a number of people dialed in, *9 will raise your hand. And so that one of the questions is about the case you mentioned earlier, the Zeta case, and in the exact caption for that, the court that it's in, and the name, the title of the case. Is it Zeta versus the TMB?
It's actually Zeta versus Mary Robinson, who was the executive director of the TMB. And you can go on the Supreme Court website, and you can go on the docket for the U.S. Supreme Court and just type in Zeta. It's an unusual name, and so you're not going to get 100 cases coming up. You'll just get this case.
Right, ZADEH, I believe. I'll put that in the. I'll put that in the chat, ZADEH. And then just another, it's a related question to what Dr. Ritz talked about HIPAA. There's a question, can doctors still declare as a country doctor? I guess if they are maybe currently a HIPAA entity, can they become a country doctor, a non-covered entity? Is that possible, is what one of our questioners is asking.
Absolutely, yes. The answer is yes. And many of AAPS members are still country doctors, and that keeps them outside of the jurisdiction of the federal government on privacy issues and maybe some other issues as well. So absolutely, and please consider doing that. That has saved many doctors against an overbearing federal investigation. The fact that they are country doctors and therefore the federal government does not have jurisdiction over them for privacy matters. Now, if they're in Medicare, the government will have jurisdiction over Medicare billing issues. If they're billing insurance companies, the federal government will have jurisdiction over them for billing insurance companies, but not over privacy issues if they're a country doctor. And if they're not in Medicare or not billing insurance companies, then the government will have less jurisdiction on those issues as well.
All right, thank you very much. So let's see. Okay, well then the question just came in, how do you become a country doctor if you have electronic medical records, or can you?
You can do it if you have electronic medical records, but you have to stop doing electronic billing. So it's electronic billing that triggers HIPAA.
And possibly electronic prior authorization,
right.
which is the thing, which is becoming more common.
Right.
So that's another thing to look out for. Okay, let's see. We have a caller with a hand raised. I think this is Dr. Thomas. Let's see if I can get you on here.
What?
Dr. Thomas, please go ahead.
Thanks very much. Yeah. Yeah, great seminar. The underlying cause of the opioid crisis, the Sacklers promoting opioids, Oxycontin, and then working with the AMA to have the pain scale. The Sacklers made billions. They put their money into art, and now we haven't gone back and gotten the money back from them. The Sacklers also sponsoring legislation to stop the buprenorphine from being processed or being used. How would that? How can that problem be solved in terms of, I guess, ultimate causes of this opioid issue, and take the blame from the physicians and put it on the Sacklers, and possibly get remuneration from their art collections?
All right, thank you for that question. Dr. Lilly, do you have any feedback on that?
No, I know that the whole OxyContin thing has been pushed. In reality, it's all the opioids. They were, the government has been pushing us to prescribe all the opioids. So yeah, the OxyContin was, that was one where the pharmacy was saying, oh, this will help with addiction, when in reality it didn't, and you ended up with having some people crushing the OxyContin pills to get an even bigger high. So yeah, that I am not up on all of the legal ramifications and what's transpired with that.
Yeah, thank you, Dr. Lilly, and thank you for that question. I think the Joint Commission had an involvement in that too at the beginning in pushing that pain scale. And I think the Joint Commission may have gotten sued too, although I was looking for more information on that recently and couldn't find it. If anyone knows any more about that, please let us know. Okay, so there's another, just a comment in the Q&A box that is, the problem is that every medicine has a diagnosis tied to it. If you are on Prozac, that means you have depression. The drug database is a way of getting your list of diagnoses without getting your medical records. Well, that's a good point.
Exactly. And that's one of the problems with the red flag laws, saying that, you know, if you're in danger to other people, we can come in and confiscate all your firearms. So that's, I know there are a lot of states that are pushing that, and there's a big pushback against that. And in some ways, we've kind of opened that up with, especially in Missouri with our Constitution. We stupidly modified it a few years ago to make it a little more amenable to red flag laws.
Okay, thank you. So let's see, we have another hand up here. Let's see, this is Dr. Righetti. Dr. Righetti, welcome to the webinar. Please go ahead.
Unmute.
Dr. Righetti, there you go. Let's try that again.
Hi, Jeremy. Can you hear me?
Let's see, you're very soft. Your volume's very low. Maybe get closer to the mic, or there might be a way to adjust your microphone. Can you try again, please?
Hi, Jeremy. This is Dr. Righetti from Warren, Ohio.
Yeah. I'm having a hard time hearing Dr. Righetti. Dr. Lilly, were you able to hear her?
No.
So Dr. Righetti, see if you have a microphone volume control, and we'll come back to you in a minute here, okay? All right, sorry about that. Okay, so here, let's try Dr. Martins. Dr. Martins, welcome to the webinar.
Hello, can you hear me?
Hi. Yes, we can. Thank you.
Yeah, hi. I wanted to let you know that on one of the Facebook groups, I don't know if it was an ER doctor one or one of the women physician group, one of the physicians posted that last week she was served with a federal subpoena because she had prescribed hydroxychloroquine, and she was freaking out and directed her to your organization. And a few days ago, she posted that she was notified that to ignore that subpoena that was no longer valid, and that one of the senators was going to speak to her. So I was wondering if you've had other people contacting you because the local or federal government is monitoring the prescribing of hydroxychloroquine.
That is a great question, and thank you for bringing that situation up. Yeah, that doctor called us last Friday. She woke up to an email from the district attorney, the U.S. district attorney, telling her she was subpoenaed and to show up at the courthouse early next month. But then thankfully Monday she got another email saying that the subpoena had been canceled, and there were various people working on trying to figure out what was going on there and to help her. The Senator Johnson, Ron Johnson, was one of them, and he spoke up about it and rattled some cages, and maybe that helped. We don't know for sure, but we have not heard from anyone else that has been subpoenaed at this point, although what we're hearing is doctors are trying to prescribe and the prescriptions are not getting filled, or they're telling the doctor, no, yeah, right, sorry, we can't fill this. And they're just some very tragic stories, like in a nursing home where a doctor is trying to get his nursing home patients these drugs and the pharmacy just won't fill them. Apparently they have the supply, but they're saying that the state regulations prohibit them from filling them. So there is some work going on to try to change that. And we heard that there might be some announcement tomorrow on that. So we're hoping to hear some good news tomorrow on that, but we are working on that. Thank you for that question.
Yeah, Jeremy, if I could jump in on that. This is Andy Schlafly.
Please.
One might wonder how the federal government has any jurisdiction over a prescription by a physician for a medication such as hydroxychloroquine. Where's the federal jurisdiction over that? And it does not have much jurisdiction, but the way it has a hook in there is through its authority over billing insurance companies. So if that prescription results in a bill going to an insurance company to reimburse that prescription, then that would establish a basis for federal jurisdiction over that under one of its healthcare fraud laws relating to billing insurance companies. So that's just something to be mindful of, even though the doctor herself is not making any money on that prescription, particularly if she wrote it for someone who, if she did it on a volunteer basis to write it for somebody, she's not making any money. So it's not apparent why the federal government would have any business in that. But what they could argue is that if the person who filled the prescription caused a bill to go to an insurance company to reimburse for that prescription, then that would establish federal jurisdiction over that transaction. So something to be aware of about the perils and pitfalls of billing insurance companies. I know it's a necessity for many of you, but those of you who get out of that area of billing insurance companies, you have an extra layer of protection against federal jurisdiction if you're not causing any bills to be sent to insurance companies.
Thank you for that additional important point. And so in the Q&A box here, we have Dr. Wax, who posted this important note. He's been working really hard in New Jersey to try to get the restrictions on prescribing there changed. And New Jersey has one of the more strict rules on this, where it appears they require a positive test in order for a prescription to be filled. So he and some of his other colleagues there have put together a petition to the New Jersey governor to try to get him to repeal that. And in the chat box there, you can see the URL to that. And please, we encourage you to add your name in support of that. Thank you, Dr. Wax, for leading that effort and for putting up that link. Okay, let's try to go back to Dr. Righetti here. Let's try again here. Dr. Righetti, could you try speaking again? Let's see if we can hear you this time. Okay, yeah, there we go. Let's try that. Go for it.
Hi, Jeremy. This is Dr. Righetti from
Much
Warren,
better.
Ohio.
Much better. Thanks for being with us.
Thank you. Thank you, Dr. Lilly, for the excellent webinar. And hi, Andy. And hello to all the AAPS members. I just wanted to comment. I wanted to make 3 comments regarding the pharmacy overreach. I wanted to say that I'm in private practice. I'm a country family practice doctor. And I have patients that come from many different counties. And I actually have patients that come from the surrounding states and Arkansas. And I've never had problems, but over the last 2-3 years, I've been seeing more and more problems because the patients that are coming from the different counties just in the state of Ohio to see me, and I have them go to my local pharmacies in my area. The pharmacists are denying filling the prescriptions. And when I call them and say, what is this? You know, I have a license in the state of Ohio. Why are you refusing to fill my prescriptions? And then the pharmacist would reply, well, we just, we're being told and having great force placed on us that we are not to fill prescriptions from another county. And so this is really concerning for me. The other thing I wanted to just say, not pertaining to narcotics, but controlled substance, I write for testosterone cypionate and 10 mLs to dispense. The patient takes it to the pharmacy and comes back with 1 ml. And so I had to call the pharmacist and say, you know, I wrote this prescription for 10 ml. Why aren't you dispensing that? Why are you giving that patient and changing my prescription? And the pharmacist just says, because that's all I'm going to dispense. And I gave them refills, like 9 refills to equivalent the 10 mLs. vial. So they're not honoring the prescription. They're going far beyond their ability, and they're literally trying to practice medicine without a medical license. The other thing I wanted to say is about the Ohio automatic prescription reporting profiling. I had become a victim a couple years ago of prescription theft, not out of my own prescriptions, but just because people can get every license from a doctor online. And there was like 6 people that apparently went to Columbus, Ohio, filled prescriptions. I'm far from Columbus. I'm near, Cleveland. So the pharmacist called me after the fact and said, "Hey, doc, I know you don't write for OxyContin and fentanyl and stuff like that, but I'm just calling you to let you know that I filled some prescriptions." And I said, "Well, why didn't you call me before you filled them?" But make long story short, these were all fraudulent prescriptions. So I right away reported it to the Drug Enforcement Agency out of Cleveland. And I also called the supervising board, the state pharmacy board in Columbus, and spoke with the supervisor and said, "Hey, I'm a victim of theft, and I don't want you to be profiling me and all this stuff." So they said, "Okay, thank you for letting it know." Well, sure enough, on my ORs, they had this big circle pie graph, and it showed like 99% of my prescribing was OxyContin, fentanyl, and it was ridiculous. It was like 6 people that were charged criminally, and they profiled that this is my writing habit. And so I called them, wrote a letter and everything, and I said, why are you profiling? Why isn't this removed? And then the pharmacy at the Board of Pharmacy said, "Oh, we don't have the authority to remove that. That's data. That's going to stay there." So here's all this inaccurate information profiling me falsely and inaccurately that's going to come down the road somewhere, someday, to hurt me. And it's frightening, and I'm really stand opposed to data banks of any kind because, as you can see, we're moving more and more to a communistic state and a country, and we're really losing our liberties. And I'm real concerned about it because it's getting very hard to practice medicine. Thank you.
Thank you, Dr. Rigetti. I appreciate you making those great points.
This is Andy Schlafly. It's interesting that the DEA looked into that because we had another APS member whose DEA certificate registration number had been stolen, and she reported that to the DEA, and they really were not interested in investigating that. She complained to them and said that because her number had been posted on the internet and there was unauthorized people attempting to use it, and this was bad stuff going on. The DEA really did not seem very appreciative to get that information. It seemed like they were more interested in going after doctors than going after people who had absconded with registration numbers improperly. The federal government does have jurisdiction over controlled substances, of course. So if there's a controlled substance and there's a prescription for that at issue, then the federal government will have jurisdiction over that, even if the doctor is a country doctor.
Thank you, Andy. Dr. Lilly, did you have a follow-up?
Well, we've got pharmacies around here have not filled some prescriptions, and they claim, well, we've got a license from the state too, and it's our job to protect the patients. And there are some, like Walmart, that will not fill anything above the CDC guidelines, and I think that's mainly because they don't want to get sued. So they are holding fast to that. Walgreens has, I've seen internal documents that say, do not fill anything more than 120 pills. So if you have someone that cannot tolerate or for some reason can't take, or sometimes the insurance company makes the long-acting medication very expensive and people can't afford it, so they have to take the short-acting medication, which means they have to take more of them. And if they have to take more than 120, some pharmacies are refusing to fill those prescriptions.
Thank you, Dr. Lilly. Yeah, I may have seen the same Walgreens internal document, and it also warns about patients who pay cash for
Yes.
for prescriptions. And we heard from a doctor whose prescriptions aren't being filled anymore because he's written too many prescriptions where the patients paid cash. So that was disturbing. Right, here's in the Q&A box here, someone's made the comment, in Texas, pharmacies will not fill any narcotic preparations for children under 12, even for an extremity fracture that was splinted and will be seen by an orthopedic surgeon in a day or two. Is this a common experience? I guess if anyone has any experience to share, put that in the chat room, please. Dr. Lilly, have you heard of that?
No, I haven't heard of that. Again, we've got ER doctors that only give you 6 pills, but but I don't know about kids. I've not heard that about children under 12.
Right. Okay. Thank you. Thank you. Okay, we're getting close to about time to wrap up here. There's one more comment in the chat room that too many individuals have access to drug databases. For example, police, pharmacies, with more added. What keeps individuals from looking up info on famous people or anybody? Public employees misuse government databases all the time. And this is from a pharmacist who made this comment. Thank you for making that.
Yeah, that's one of the big problems. They'll say, well, these aren't going to get hacked. PDMPs are usually not hacked. The problem is there are so many people that have access to that. There's no way to stop individuals from looking up somebody's prescription practices. So, it's not the big hacker that gets a million things off the database. It's all the little individual ones. There are hundreds of thousands of people that have access to the database. And that's the big problem, is individuals looking at individual parts of the database that they shouldn't.
Yeah, the state of Maine, they have a list of everyone who has access, and it goes A through L. And in each item, A through L, there's, just a whole host of entities in each one of those lists of who can access the database, their database. Yeah, it's shocking. Thank you.
Okay, it looks like we're winding down. Are there any questions left in the queue, Jeremy?
I don't have, let's see, not in the Q&A. I don't have any more hands raised at the moment. Someone is asking about if the country doctor is a term of art for HIPAA. Well, the court actually, HHS actually used the term country doctor in their court filing related to our suit. APS sued HHS over HIPAA, and if you want to know more about that, email us afterwards and I'll send you the exact reference to country doctor that HHS used in their reply to our lawsuit.
That's exactly right, Jeremy. We sued in 2001 to challenge the privacy rule, because it really is not a privacy rule. It's just a bureaucratic burden on physicians, and it actually ends up in the violation of patients' privacy. So we sued to overturn that. And in response, the government put in its papers and said, well, you don't have to worry about the privacy rule because you can just become a country doctor and then you don't have to comply with it. So that term comes from a court filing by the federal government in our lawsuit against the privacy rule back in 2001. And we have many members who successfully used that country doctor exemption ever since.
Thank you.
All right. Well, let me wrap up here. Let me say thank you very much to Dr. Lilly for the research that he's done, the advocacy that he's done, a very informative presentation that's very relevant to our practices right now. So thank you for all the work that you've done. Thank you to Jeremy for all the logistical organizing of this webinar series. And thank you to all the participants. We're really glad to have you here. This is an ongoing series, bi-weekly. Dr. Eskew is up next in 2 weeks, and we'll hope to see all of you back. and we will keep in touch. And I want everyone to stay safe. And staying safe might at one level mean staying safe with your health, but probably in our group we say stay safe from the regulators. We'll look forward to seeing you the next time. Night, everyone.
All right. Good night, everybody. Thank you very much. And please keep an eye out for a post-event email with an evaluation form to fill out so you'll get your CME. That'll be coming in about 30 minutes from now. All right. Thank you all again. Thank you, Dr. Lilly, for your excellent presentation. Really appreciate it. Thank you, Andy, for joining us tonight and adding so much. And Dr. Emmons, thank you for your leadership here and for your help tonight, too. Very much appreciate it. All right. Good night, everybody.